morning. Welcome to the Court of Appeals. Of the matters that we will be considering today, there are two of those where oral argument is in order. And the first of those is Hoops versus Hoops. The second of those is Kyle versus Kyle. We'll take Hoops first, and I see counsel is at the appropriate tables and ready to go. A general reminder, we allow 15 minutes aside for oral argument. Appellant can save some of that time for rebuttal. It looks like appellant has already advised the clerk that you'll be reserving 3 minutes for rebuttal.
Yes, that's correct.
The other pointer is that per mandate of the Constitution, our proceedings are recorded. They're also live streamed, so it's important as you're making your argument that you don't stray too far from that microphone, or we'll lose some of what you're saying. We would ask counsel then to state their appearances for the record.
Your Honors, Carissa Urask and Dick Baldwin on behalf of the appellant, Tess Hoops.
And you'll be arguing?
Yes, Your Honor.
Very good.
Good morning, Your Honor. Russell Yanni on behalf of Mr. Scott Hoops.
And you'll be arguing?
Oh, of course, yes, Your Honor.
Yeah,
Thank you.
very good. With those preliminaries out of the way then, unless I've missed anything, we'll hear your argument.
For two reasons, the district court erred when it denied Tess's motion to clarify. First, at trial, the district court intended to and did in fact divide the non-RSU account evenly between the parties. And second, 8 months later, at the motion to clarify hearing, the district court clearly erred when it found that the non-RSU account had not been addressed at trial. On to the first point, the district court at trial intended to and did in fact divide the non-RSU account evenly between the parties.
So what do we do with the statement from the court that it didn't?
Well, that was the statement that the court made 8 months later at the motion to clarify hearing.
But as to its intent, are we second guessing what the district court says it intended to do, or?
Well, I wouldn't call it a second guess, I'd call it a correction. I would say, typically most of the time, yes, the appellate court would defer to the district court on its intent. However, there are situations where the district court does make an error as to its intent, especially when it was 8 months before a trial and the district court even acknowledges that it can't really recall what happened. That might be an unusual circumstance and certainly not typical, but clear error review exists for a reason, and it's because district courts do sometimes make mistakes.
And what do we do with her observation that, well, Mr. Hoop should do the right thing? She seems to have in mind that at some level, a sharing was in order. And doesn't she, not admonish per se, but doesn't she register the thought that it is incumbent upon him to make a division if that's what was contemplated?
I think that statement from the court is very curious, and I think it certainly reflects that the court had no intent at trial to award this account to Scott, and it certainly did not award it to Scott. It's a little hard to square that statement with the court's decision, to deny the Rule 60A motion, but I do think that statement from the court is certainly indicative that there was never an intent to award this account to Scott, and then in fact the intent was to divide it evenly between the parties.
Is that necessarily true? I mean, as a category of cases, domestic cases can be, I think the legal term is messy. And so often issues kind of rise post-judgment that aren't addressed at trial, and the court can have views on what moral responsibilities might be there, but it can differentiate between that and the legal issues of what was and was not presented at trial. Are those necessarily in conflict? Her statement that you should step up and pay this, and at the same time saying, I don't believe this was raised at trial, those can exist in the same space, right?
Well, they could, except for here, the account was addressed at trial. So Tess testified, we have this E-Trade account in a couple of different ways. She explained that there was some stocks they had acquired just as part of Scott working there, and that there was some stocks that they had purchased with their income. Both parties also admitted exhibits that the court, or they offered exhibits that the court accepted into evidence that identified these two separate E-Trade accounts. So when the court said, well, this just wasn't addressed at trial, there wasn't an exhibit, that was just clear error, because these two separate E-Trade accounts had been addressed at trial. And not only were they raised at trial, but the parties had agreed in their pleadings that stock accounts should be divided evenly. That's what Tess asked for multiple times in her testimony. And then also the court's ruling and the decree are indicative of the court dividing that account evenly between the parties.
Now procedurally, here on appeal, you're claiming that this is a clerical error, right?
Yes,
Now, in the motion that was filed below, Rule 60A is not mentioned, correct?
yes, that's correct.
And I also did not see, and I reviewed it this morning, although I'll admit that that was a rather speedy read again this morning. I did not see the terms clerical oversight or omission in the motion or in the hearing. It doesn't appear that the motion that was filed was for a 60A clerical mistake, rather than it appears to be what it says on its face, which is a motion to reconsider or to, quote, clarify. Clarification can be something that was not said previously, whereas a clerical mistake is, no, you meant to do this, and it got memorialized incorrectly.
So
Do I have that wrong, or?
well, we admit that we didn't use 60A, and I think you're correct, we didn't use clerical or omission. But our exact argument to the district court was your intent, and we did use the word intent, was to divide this account evenly, and we also argued you did divide this evenly. And that's the exact argument that we're making on appeal. There is no difference between those two arguments. I'll admit we've given a more, specific framework here on appeal, but the exact arguments are the same on appeal and in the district court.
How would this differ, a Rule 60A clerical error, differ from a Rule 59 motion for additional findings? If you had received the final documents in this case, and you're like, you know what, that's just not addressed. And we thought it was addressed at trial. The typical procedure is then to, under Rule 59, ask the court for additional findings or to correct erroneous findings. Why didn't that happen here?
Because from our perspective, that wasn't necessary and that wasn't even the right type of motion. So at trial, we had specifically said, as the court was making its ruling we asked for clarification. We said, when you say half of retirement, that's half of stocks, and this is on page 1553 of the record. And the court said, well, everything that is listed as retirement. So when the court says listed as retirement, it's referring to the trial brief, and that's on page 637 of the record. And if you look at that, there's a heading that says retirement accounts. And then within that heading is talking about pension, retirement, and stock. So what's happening at trial is multiple times the court and the parties are using retirement as sort of a umbrella term that includes these E-Trade stock accounts.
Even though they weren't technically retirement accounts.
Yes, but that's sort of the phrasing that the court and the parties both used. You can see in the trial brief, you can see it on 1553 of the record. And if you look at the trial brief and you look at paragraph 14 of the divorce decree, they're very, very similar. And within paragraph 14 of the divorce decree, the court says division of retirement will be pursuant to Woodward. And then within that same paragraph where the court is talking about retirement, it then specifically says the RSU account is awarded to Scott as part of his income. So there again, you see the court is talking about the stock account as part of retirement. So when we see that, we're reading the decree within the context of trial, and we're understanding, yes, the parties in the court used retirement to include this stock account. So from our perspective, there was really no need to file a Rule 59 motion. We just needed to correct perhaps the omission that the decree, when read in context, we think it was correct, but sort of read isolated, maybe was not correct because retirement is not the word we typically use to include a stock account, but that is how the court and the parties used it at trial.
Wasn't there sort of a what's the word I'm looking for? Basically, council below kind of gave it up in the sense of, I'm looking at record page 1554, and which is the discussion that you referenced earlier. Court says everything that was listed as retirement account, that there was a kind of, I don't know the different kind of stocks. There was a kind of stock that was on the pay stub that we calculated as income. Council says yes. So not that one, the court says. But then council says, but then everything else? And counsel for Mr. Hoops below said there are no stocks. The RSUs have already been awarded to him because we included those as income. And counsel says, yes, right, yes. So doesn't she just kind of allow, if there's any kind of confusion about what stocks are included or not stocks, that she just kind of lets it go?
No, I think council was referring to, yes, we all agree that RSU account is not being divided because it is being awarded to Scott as part of his income. I think that's really the best reading of that part of the transcript. I mean, it is hard because it's a cold transcript, but I think that's the only way to read it that's consistent with how the parties in the court were talking about these accounts. And certainly we never at any point suggested that we were conceding that this other account was like not marital property or that it had been awarded to Scott or that it should be awarded to Scott. And he didn't even ask for that himself. So there certainly would have been no reason for us to concede that at any point because he never asked for it. And the court never made any findings that would justify awarding it to him. So I think another important thing in addition to the decree, the ruling at trial, the parties' pleadings, is just sort of this background principle of divorce law that's fundamental, which is there is a presumption that marital property is divided 50-50. And we've already touched on this a little bit. But if the district court had wanted to award this account to Scott, it certainly could have, but it would have needed to make findings on the record. And it didn't do that. And again, as Scott at no
But
point.
that would have been a Rule 59 issue, not a Rule 60A.
Yeah, our point is not that the court awarded it to him but didn't make the correct findings. Our point is the fact that there are no findings is just further indicative that the court intended to divide this 50-50. It's not that these findings are missing, it's the fact they aren't there is only further evidence that the court intended to follow the presumption and divide this account 50-50. Especially because elsewhere where the court did award something to one party over the other, it made explicit findings and it clarified it on the record and in the decree. And I don't think that presumption is necessary to your ruling, but I think it is certainly strong evidence of what the court intended to do here. So the second point is just the court clearly erred when 8 months later at the motion to clarify hearing, it concluded that it did not, that it had not addressed the non-RSU accounts at trial. And I think an important point here is just that I think Scott has conceded that point because he argues that the account was awarded to him. And if that's true, then the court did address the non-RSU account at trial. And the question is just, who did the court award it to? And there's just no evidence that the court awarded it to Scott, whereas all the evidence demonstrates that it intended to divide it evenly between the parties. And with no further questions, I'll reserve my time for rebuttal.
Thank you. We'll hear from Appellee.
Thank you, Your Honor. Your Honor, court, I would ask that the court take into account that this is an appeal from a 60A ruling and not a substantive ruling where the appellant is requesting that the court review whether or not the court erred in making a finding that there was nothing to clarify under Rule 60A. The statement that there was no award of this account underneath, I think, is incorrect. The court awarded what I would describe as the non-retirement. I'm sorry, I have this actually written down really well, but it's the non-retirement post-separation non-retirement accounts. Thank you. There we go. post-separation non-retirement accounts. So there were a number of accounts that were in play, in checking accounts, credit cards, things like that. And there had been a substantial dispute about whether those amounts that went into and out of those accounts were properly spent or otherwise, improperly spent. And that included discussions about whether or not alimony and child support needed to be changed and needed to be refunded because the amount that was ordered at temporary orders and the amount that was ordered at trial were substantially different. The court said that the parties have spent what they have spent. That's what was said. The parties have spent what they have spent. I'm not going to unwind that. And so any of the amounts post-separation are going to, they're going to be left the way they are. The amounts pre-separation, those amounts are divided evenly. And so this falls squarely into a post-separation non-retirement account, where some of the money that was in the account was their pre-separation, some was their post-separation. And so the court's order is that the pre-separation portion of this account should be divided evenly. That is the order, and that is not what is being requested to be clarified here today. Today there is a request to find that somehow the court made a mistake and classified this ESPP as either a retirement account, which it is not, or that or that it was just somehow completely left out.
But you do have to acknowledge that there is no specific designation of this account in the divorce decree. I mean, the divorce decree discusses bank accounts, and it discusses, paragraph 14, it discusses the specific restricted stock units account, and then it says retirement accounts. So there's no specific designation of this account in the divorce decree.
I would agree with that, Your Honor, but I would also argue that I'm not sure if bank accounts would be a specific description of all of the different credit cards and other financial accounts that would be encompassed within perhaps the word bank accounts. And this is at best an investment account.
But doesn't that go against, I'm sorry, I'm confused, but doesn't that go against what you're arguing? I mean, in paragraph 22, the divorce decree says, due to the significant length of separation before parties attended trial, the court orders the bank accounts to be divided 50-50. If we're considering this a bank account, a financial account, doesn't the decree say it should be divided 50-50?
I believe that it says that the portion of the bank accounts attributable to the premarital, pre-divorce, or
Pre-separation.
thank you, pre-separation, that those accounts would be divided evenly. In the initial financial declaration offered by Mr. Hoops, this account was listed at, I think, somewhere between $11,000 and $12,000. And so one half of that amount would be $5,000 or $6,000. That would be the equal division that we're talking about here. After that time, the court entered temporary alimony, and some of that amount of alimony Mr. Hoops used to purchase these stocks. The parties were able to purchase whatever they wanted. And so when the court later found that the parties have spent their money how they've spent it, this dovetails very neatly into that concept of, as he was paying alimony, essentially it was an equal division of his income. She was able to spend the money how she wanted. He was able to spend the money how he wanted. Some of his money got saved. And so to come back later and say that now this $5,000 that she was entitled to at the time of separation, that now that has grown substantially when he used his post-alimony money to fund it, that seems fundamentally contrary to what the court was intending when it said that everybody has spent what they have spent, and so I'm not going to try and unwind that. We would need to go back, if the court were to affirm, we would need to go back and we would need to unwind the credit card spending that he alleged that she had done for attorney's fees, and the court specifically said it was not going to do that. And that was a substantial amount of money, but the court made no findings as to that amount of money. It just noted that there was a lot of argument about that. So the specificity with which the court listed these different accounts isn't fatal to the idea that the court considered it, especially since her value at the time of separation was between $5,000 and $6,000. I know I'm not that good. I think that the key issue is just that, Your Honors, is that the ESPP account falls within the ruling that the court made. And so we are not here to try and, there is a correctness review that is going on, but that correctness review is not about whether or not the court made a correct division underneath. That correctness review is about the factors that are outlined in Peck. Whether or not the trial court was clear, whether there was a clear order, whether or not the judgment rendered reflects what was done or intended, and whether or not the error is the result of judicial reasoning. Or I'm sorry, whether or not the error is clear from the record. In all of those areas, the trial court, there was an order. That order divided non-retirement post-separation accounts. That order was clear. It divided non-retirement post-separation accounts. The pre-separation accounts would be divided evenly. And then it also, there's no error that is clear from the record because at best, the error is that counsel underneath in the motion to clarify classified this as a retirement account. When she went in, she argued that the court had equally divided the retirement accounts and asked that this account, and to be clear, all E-Trade accounts, including the RSU account that had already been addressed, that all of those accounts would be divided by Woodward. And so if there's any error, it's in a reading of the record, but the reality is that the order is clear. It's the retirement accounts get divided in half. Any post-separation amounts, those are, the parties spent what they spent is, I guess, what the court said. And then anything pre-separation would be divided evenly.
So, but isn't the court's comment that this account, wasn't discussed at trial or not brought up at trial, isn't that a curious statement if she really did intend that all of these other accounts, all the financial accounts, go with each person post-separation?
I think that given the
What are we supposed to do with that?
I think that given the context of where the judge, the information that the judge had received during that hearing, there was a question about whether or not there was an E-Trade account that was brought up in terms of the retirement accounts. But the information that she got was largely provided to her by the parties. And so Ms. Mary Patton Green, she provided the information that this was a retirement account. Mr. Rifleman, he was new counsel, and I don't remember what he said, but he may have argued that this was brought up. But it's clear that he was questioned about his employee stock purchase plans during trial. It's very clear, and he was questioned about that by Ms. Patton Green. So it was discussed during trial, and I think that what happened was that the attorneys failed to point that out to her, and so their assumption was that it had not been brought up during trial. I will take this as a hint, and I appreciate the time that you've offered me.
Well, no hint intended, but I have often had occasion to observe that the time on the clock, it's a maximum, not a minimum. And we're always pleased to inherit 5 extra minutes or so. We'll hear from appellant, 3 minutes on rebuttal.
So the phrasing the parties have spent, what they have spent, what the court is talking about there is specifically bank accounts. And on pages 15 through 18 of our reply, we sort of walk through all the record sites, so I won't repeat them here. But basically what was happening was the parties had bank accounts, meaning like Mountain America Credit Union accounts that they had, like a Visa or a debit card for. And with those accounts, after their separation, the parties had basically spent all the money in those accounts. So when it got to trial, the court said, look, after separation, you each took money from those accounts. And I'm just ruling right now that that was equal taking and we're not gonna revisit it. You spent what you spent and we're just gonna divide that as of the date of separation. But then for everything else, the court said it will be date of divorce because that's more equitable. So when we're talking about this E-Trade stock account, it is not comparable to bank accounts because the parties were not spending the money in that E-Trade account. They didn't have a debit card where they were both taking out money equally and the court ruled, well, you took it out equally. Therefore, we're just gonna say it was equally divided at the date of separation. Again, if you look at paragraph 14 in the divorce decree, that's the court specifically saying we're going to do it the date of divorce because that is more equitable. And that is really in line with the court dividing that non-RSU account evenly as of the date of divorce because that is more consistent with what the court was doing. And dividing the non-RSU account evenly at the date of separation is not consistent with what the court was doing. But regardless, if you take Scott's position, he is still agreeing that there was an error at the motion to clarify hearing. He is conceding that that account should have been divided at some point. So the question then really isn't, should this account have been divided? The question is, what was the court's intent at trial? And all of the evidence, all of the background principles of law point to the court's intent was to divide the non-RSU account evenly between the parties. Because there was no indication that the court was doing anything different than following that presumption. And in fact, its ruling and the divorce decree are very consistent and we think demonstrate that it did in fact award that account or divide that account evenly between the parties. And for those reasons, we would ask this court to reverse and remand with instructions to divide that account evenly between the parties as of the date of divorce. Thank you.
Thank you. We appreciate the arguments from both sides. As is our custom, we'll take the matter under advisement and let you have a written decision as soon as we're able to get that taken care of. And we will be in recess until time to call our 10:15 matter.